Welcome, Ashima ma'am. Let me tell the audience about your marks. Ashima Mandla got paper 1, practice and procedure of Supreme Court, 81 marks. Paper 2, drafting, 61 marks. Paper 3, professional ethics, she got 75 marks. And paper 4, leading cases, 88 marks. So this is a fantastic marks as per concerned AOR examination. And I will request Ashima ma'am to speak on practice and procedure, because I know that Manoj have given you the subject to speak on leading cases. But leading cases, we have 2 speakers today. So Gurpreet cover that. But you can speak on leading cases also. But along with the leading cases, you speak on practice and procedure also. So before that, you tell us your background, okay, and how you get motivated to give this examination, okay, and then you tell about your practice part of this examination altogether. And even though some points are repeated in from earlier speaker, if some point are repeated also, no issue about that, because we will publish this video as a full program also, and then we will publish this video in different fragmentation also on different subject, different. So we can share that videos also in Nani Palkiwala National Law Club official group 1 and 2. We will share that the videos also. So people will enjoy it forever. So, Ashima ma'am, now mic is with you.
Thank you so much, sir. Good afternoon, everyone. Just a small correction. My name is Ashima Mandla.
Okay. Sorry for that.
No, please, sir.
Instead of Mandla, Mandla is there. Yes.
Thank you so much, sir. And I'm very grateful to be given this opportunity to address such a prestigious club. Mr. Nani Palkiwala's legacy continues for generations to come, and it's an absolute honor to be able to address an audience today and in a club which is named after him. So far as my background is concerned, I am a first-generation lawyer. I have been the junior of Mr. KTS Tulsi. My primary practice is in criminal defense litigation, both white collar as well as blue collar. I've had my own firm for the last 6 years by the name of Mandla and Singh Law Chambers. The AOR exam I have cleared in my first attempt, and as much as with everybody else who's been speakers today, because we keep very hectic schedules. So even my preparation was only limited to about 25 to 30 days, not more than that. But given if you've primarily practiced in Supreme Court, these examinations would not be so difficult for you to pass in the first instance, given that the content and the syllabus of the papers is not very far from reality. It is something that you would anyway need as a part of your practice and procedure in the Supreme Court, given we have 4 papers. The first is, of course, practice and procedure, which is predominantly the Supreme Court rules, along with the Constitution of India, because Supreme Court gets all its powers from the Constitution of India, unless some specific acts also empower Supreme Court with statutory appeals. And then there is drafting, professional ethics, and leading case laws. So far as how my preparation has been, I took in some advice from my seniors who had cleared this exam in their first or a subsequent attempt. But the basic structure which I was told was, and I followed it, was that I am a believer of the fact that if we do not rely so much importance on the guidebooks or bookies, it will be much better for understanding the concepts if you actually go back to the bare reading of the material. So if I have to now talk about practice and procedure, there is one book, and that is of Mr. Venkataramani, who is our current Attorney General for India. His book is the book which is also being used by examiners, because we were recommended this in our lectures by the registry, which I held every year a month before the examinations. So read it cover to cover. Your concept clarity will definitely enhance to a great extent with that. And coupled with the practice and procedure book, as well as the Supreme Court rules. Now, because Supreme Court has its own rules under the Supreme Court rules of 2013 is the latest edition that is there. And apart from that, there are some noted leading case laws which have to also be seen for this paper. One important thing that one must keep in mind is that even though leading case law seems to be a separate paper, but across these four papers, there are case laws. So this is something which was not very clear to many of us till the time we didn't sit for the registry held lectures. And it is only then we understood that the format is that no matter which paper you are giving, of course, you're talking about concepts in practice and procedure, but the concepts application would be through judicial precedents. Then, when it comes to drafting, now what we were told by the examiners last year was that not only do we have to only restrict ourselves in the drafting paper to the bare format of how, see, we all know that in terms of the Supreme Court rules, there is only one format which is given in the rules itself, which is Form 28, that is for SLP. Apart from that, there is no one fixed format for any of the other drafts. But all the inferences have to be taken from the rules itself to structure our drafts. But even apart from that, we were told very categorically that we would, of course, fetch better marks on where if the content is relevant in terms of the cases as well. So we were asked to be aware of the developments of the Supreme Court in latest judgments which took place over the last year, because the relevancy came in that when the questions came in on the drafting paper as well, we were told that at least to have two questions of law, four grounds, and in those grounds, if you're able to cite some relevant judgments to that extent, it would fetch better marks. And then professional ethics, for one, there is, of course, the Advocates Act, the Bar Council of India rules. Apart from that, everything is again, it's even professional ethics is heavy on the relevant cases. And that list is all of that is already there in the AOR section that you find on the Supreme Court website. And of course, the examiner and whoever would be conducting the registry lectures this year would also roll out some case laws for your perusal. And then, of course, leading case laws is the only one which has a certain number of 64 case laws which are given on the website. But apart from that, what we were advised last year was that also see the follow-ups of those relevant cases. Like, for example, there is the judgment on reservation of Indira Sani. And apart from that, we were asked that it would lead to better marks if you can also see the follow-ups in other reservation cases that have taken place, like the Maratha reservation judgment, which came out, which became the 103rd constitutional amendment. So this was just something as a matter of advice that came to us, that given I had prepared to speak on latest case laws, but now sir is requesting me to do practice and procedure. So if I'm allowed to share my screen, sir, I'll be able to show uh, how the notes came about. So it will be a little more practice oriented and easier for people to prepare as well. For example, last year, we were given this slideshow, which is available on the Supreme Court website, of practice and procedure by Vibhadata Makhija ma'am. And the advice across all papers were that they are not looking for you to just fill up pages. Even if you are attempting a 20 marker in, say, 3 pages, but those 3 pages have to be content driven. If you're going to be just thinking that you will just fill in more number of pages and that will fetch higher marks, this was absolutely strictly advised against. It has to be crisp, to the point. You may write in bullet points, but it has to be relevant to what the question is seeking. So because it is easier for the examiner to also assess whether you actually understand the concept or you're just trying to fill pages. So what we were asked was, they of course divided the entire Constitution of India, the powers of the Supreme Court, right from Article 131, and it went up till Article 142, and the relevant judgments on that. So this was just a brief pointer-wise format that was given to us to, first of all, break down that particular article of the Constitution empowering the Supreme Court for conferring any kind of jurisdiction on it, the special features, if any, and then, of course, the judgments on that. Now, judgments, again, we were advised not to only write in a couple of lines, but ideally give an entire background of how that judgment came about. And the way you break down a judgment is always the facts, the obiter dicta, as well as the ratio decidendi. All those components together would give you a holistic picture of what the judgment actually states. So this was, for example, and especially this is important because Kunya Ahmed, for example, for the last couple of years, there have been cases coming, questions coming exactly on Kunya Ahmed, to ask that if the you approach under 136 to the Supreme Court against a review dismissal. And for example, in the Supreme Court, in the SLP against the review order, dismisses the SLP in limine, then can you go back to the High Court? And this is a question of law which has now again been sent up to the larger bench in the Supreme Court for the consideration at the moment. So same way, for all jurisdictions, this slideshow is easily available on the website. One may access it. It gives you a structure. You can read up more about it in the practice and procedure book, as well as you can actually just download the actual judgment and make your own notes. So for example, for everything that was mentioned in this slideshow, I made an endeavor to make my own case notes on each of the judgments so that it is crisp. You don't have to, because right before the exams, these are 4 papers that are going to be back to back. Now, we can't think about while we are sitting for the examinations to read something which the content of which is new. So it is preferable that you make your own notes at your time and pace in the manner in which you prefer making them. And it will be much easier for you to just have a bare revision of them. So these are the notes which I made in the end. My absolute advice to everybody is that please don't make an endeavor to make these notes by reading articles. It is when you are at the Supreme Court sitting for these examinations, we are anyway at least 5 years into practice. And the content of these papers is something which I found to be absolutely very relevant in your day-to-day practice as well. After going through the entire material, and I say this with an absolute candidness, that I started applying the interrelated principles, which, these are judgments which you must have read in your college days. But sometimes you lose connect with it because you're reading them only perhaps for examination purposes. But if you actually make an endeavor to understand these judgments, they will enhance your set of skills and knowledge while practicing not only before the Supreme Court, but because across forums across, and it actually leads to you developing a better skill set for your research and even for your drafting. That substantially increases. So I feel the curriculum that has been laid out for the AOR examination is a must for every lawyer which is practicing before the Supreme Court, whether or not you have any aspirations to just be an advocate on record. And I believe that CGI, Mr. Chandrachud, he was very, very categorical when our induction took place, that AORs should not be reduced to mere signing authorities. And there is, of course, a duty that is casted upon an advocate on record to ensure that even if there is somebody else who's drafting and you are merely filing it, but one should just not become a signing authority. You must go through the entire draft and see whether it is actually in line with the statutory principles and in line with the judicial precedents as well. Because he mentioned that at the end of the day, it is your name on the file. So you have to have that sense of responsibility towards the court, because at the end you become officers of the court, and you are held responsible for it. And there have been incidents in the recent past where the judges of the Honorable Supreme Court, they are pulling up advocates on record for not having this kind of due diligence and seeing what is being filed on their behalf. So this was actually very wise advice, because while you're embarking on this journey, you must understand the seriousness that it holds as well. So these are some, I just wanted to show that I made these kind of notes. It was far easier for me to recapitulate a day before the exam, just to go through those 30, 40 odd pages, and of course, written notes. See, to be very fair, for example, the slideshow that is given out, these are in mere pointers, but one will have to make their own notes as well, to not only pass this examination, but to also take away those learnings and findings with you. Now, so far as Supreme Court practice and procedure is concerned, we are, of course, bound by the Supreme Court rules. And apart from that, you can also download this handbook on practice and procedure and office procedure, which is there on the Supreme Court's website. And this will also, as you can see, it has in absolute detail a lot the jurisdictions mentioned, because Supreme Court also has statutory appeals from at least 23 legislations, and questions do come in on that as well. And a lot of people get very confused about which will fall under original, appellate, or extraordinary jurisdiction. If you actually look at this PDF, which is available on the Supreme Court's website, it will give you a lot of clarity, because there are certain questions that are recurring across papers which say that enlist the different jurisdictions of the Supreme Court. So no better place than looking at the Supreme Court manual itself for this. So this came around much later. We were not informed about this in our lectures last year, but I just stumbled across this, and ever since then I've kept it in the office, even for filing purposes. It's of great help, because it tells you exactly what article to invoke when you're filing something. So it's a great referencer. It's a slightly lengthy PDF, but skim through it once, and this will be something that ideally, once you clear this examination, or even otherwise you are practicing in the Supreme Court, you should have it in your office, most definitely. Now, apart from this, so far as practice and procedure is concerned, the best way which I undertook from what worked for me was that I opened the Supreme Court rules and took it order by order, and took the book of practice and procedure by Mr. Venkataramani and this manual by the Supreme Court, all together at once and then made my summarized notes on each article along with the order corresponding to it. If you do it in this manner, it actually helps you prepare for two papers, because the drafting paper that you will attempt the very next day will also have this exact interplay of Supreme Court rules and practice and procedure. And why that is relevant is, if I just open Supreme Court rules for a moment and show it to you. Now, for example, we look at so from here, you start with appeals in general. Order 19 is civil appeals. But I just wanted to show you how it will help you in the drafting by looking at the writ section. Since I mentioned it a couple of minutes ago, that there is no fixed format in the Supreme Court so far as petitions are concerned, apart from SLP. Now, what declarations to write when you are drafting a writ petition or a PIL, all of that you will find exactly in here. Now, if you look at SLP, which has come in first, civil SLP is order 21, criminal is order 22. Now, if you do your drafting paper, you would see that when we say before the Honorable Supreme Court of India, special leave petition, civil or criminal as the case may be, and then we write under Article 136, read with order 21, if you are doing a civil SLP, and order 22 if you're doing a criminal SLP. And along with that, you will see a lot of AORs who also specifically mention that the form is 28, of course, and they say 2 or do sub-rule 2, order 21, because the rules are here. How exactly an SLP has to be filed? Say, for example, it says it has to be in the format of form number 28. Then you have to have chronological list of dates. Then the because as anybody who has done even one petition in Supreme Court knows that unlike the drafts that we do across district courts or high courts, where we are at liberty to mention the facts in the sequence as we wish to inform the court, in the Supreme Court, it has to be done chronologically. Otherwise, the registry will mark defects. And apart from that, there is, of course, there's no collie system. So that's why it says that it has to have, for each of the date have to be separately furnished. So you will also see all documents shall be indexed separately. This is where you come to know that the annexures can never be collie in nature. So if you do Supreme Court rules, practice and procedure properly along with the constitution, with the material in hand, you will be able to prepare actually not only for your Supreme Court rules paper, but for your drafting paper, at least for the formats. And then, of course, the content is something that you will have to put in yourself, and at least 5 years minimum being at the bar, that should not be any kind of hindrance to anybody.
Very nice. You nicely mention everything, and how you can prepare in one study 2 papers. That is very nice idea.
So, because realistically, this is something which I encountered as well. And near closer to the exam, you will see people will start reaching out for that. We need a draft for a writ petition. We need a draft for an election petition. To be very honest, apart from the SLP's draft, there is no other structured format that is there under the Supreme Court rules. There are some PDFs which are circulating for the last couple of years, on handbooks on drafting, but all those drafts are mostly from the 1966 rules, which
Correct.
have been discontinued ever since the 2013 rules have come in. And ever
Mm-hmm.
since then, there is no one book which is covering all the drafts. So this, as a matter of practice and procedure, even we follow this every time we make our draft, that anything you need to know, whether a certificate needs to be there, certificate of an AOR is there, or that of a senior advocate is required, like that of in a curative petition, or any declaration in a PIL is required. Everything is already mentioned in the Supreme Court rules. So one has to just read them and make your own drafts accordingly. And then, of course, you can check along with each other. And by then, Supreme Court is actually fairly flexible on a lot of drafts. For example, which is something is that if you file a transfer petition and you need to file you also want an ex parte stay. In SLP, you have a prayer of interim relief within the SLP format itself. So there is no separate IA that goes. But when you do a transfer petition or a civil appeal, then the practice on ground reality is divided. Some people file an IA for ex parte stay, and some people use the SLP format, modify it to that extent, and they include an interim prayer clause within the petition itself. Both are acceptable because the registry is not going to be marking defects on that in practice and reality. The only difference is that unless there are some specifications of rules which are given under the Supreme Court rules, then you must follow that. Apart from that, on smaller issues like these, it is fairly flexible. Like this came in last year as a question, and I'm transgressing to another paper, but it just struck me. So it came in the last year's paper, in the drafting paper, that you're filing a review against a judgment, and you are not a party before the Supreme Court. So in that case, a lot of people forgot to mention an IA for permission to file a
Yes,
review,
yes,
the
yes.
way you have permission to file SLP.
Correct, correct.
So it's the same way, if you're a de facto complainant in a matter and before the High Court you've not been a party, you can come to the Supreme Court. All these jurisdictions you'll understand when you're actually reading the practice and procedure paper, that even if you're not a party, you can still approach in an SLP. So how that would logically transgress into your drafting paper is that if you're filing an SLP, you've not been a party in the impugned proceedings. So in practicality, you will have to file an IA seeking permission to file an
Correct.
SLP. So if you actually think about it from a practical standpoint, you will learn so much about the Supreme Court functioning by just sitting and studying for these examinations, that it will give you a lot of clarity thereafter. The number of defects in your filings will reduce, and you'll also, it actually happened to me, sir, in reality. Right after this, somebody came to me for a transfer petition, and they asked me to be an AOR for their filing. So they gave me the draft. I had a look over it. And then I told them, I said, you're invoking the wrong article in this. Your sections are wrong, because then in transfer petition also, there are categories. You have a transfer under 406 CRPC, you have a 25 CPC, and then you have a Article 139A of the Constitution of India. Now, all of that has to only be seen in light of what exact relief you are seeking. So it even though the SCR says it combines the rules for Order 25 CPC and Article 139A together, but these are not to be mentioned together in the petition unless and until you fall in a combined category in
Correct,
this.
correct.
So this was something, when you realize that if you actually understand that concept, in practicality, it will become so much better than to have the embarrassment of redoing your draft if the registry points it out, or better, or far worse, if you lose in court because you've invoked the wrong jurisdiction, and in the first instance the court says that this is not maintainable. How did you even invoke this? So if one has to see it from a practical standpoint, then I believe it's an absolute must that anybody who's practicing in Supreme Court should necessarily undertake the course material, if not sit for the examination.
Correct.
So
And
it's
and
great
that and
learning
that and
in
that
this.
specific requirement of 1 year practice
sir.
under the 10 more than 10 years practicing AOR. That should be followed. If a
Yes, sir.
person followed that, and if he goes to each and every sections of registry, each and every sections of codes, that time practically he will prepare. Otherwise, 50% student of AOR candidate, they are taking only that certificate from AOR for the
Correct.
sake of that procedure only. But if they spare their 1 year valuable in Supreme Court physically, that will give them more inputs, more input.
So the greatest learning for this paper is it actually the preparation that we've had by just being in courts. So if you, even if you're not an AOR, you worked with somebody or you've had your own matters, because I've been appearing before the Supreme Court right from my second year. The first year, not supposed to. Once you enroll, you're not actually supposed to be appearing before the Supreme Court as per the rules. But of course, you go and assist your senior in those matters. And we've made it as a matter of habit since the inception that even if you're engaging in AOR, we used to get the draft vetted from the AOR, but also go to every section ourselves to get the petition listed. And then you realize that if you actually want to do it, you can do the filing and the listing in the same day, and your matter can come in the next day as well, if you understand the procedure well enough. Because sometimes there are absolute necessary matters which required urgent consideration, whether it's an anticipatory bail or any kind of order where you need a urgent stay, for example, in a demolition matter. So you have people who are filing it in the morning at 10 o'clock when the counter opens. And by 4 o'clock, you have to get everything, your registration verification, you have to get your cable clearance. And 4 o'clock, you mentioned before the listing registrar, your matter will appear on the next day.
Next day.
So if that training is actually undertaken, you will understand.
Yes, I think some network issue is with Asima ma'am, but no issue. Program is on right track. So friends, I hope you understand all the glimpse and how to crack this examination of AOR. और मैं इसमें ऐड ऑन कुछ चीजें करना चाहूंगा प्रैक्टिस एंड प्रोसीजर में, जैसा ड्राफ्टिंग के बारे में बताया आसिफा मैम ने कि इसका कोई ड्राफ्ट का है, तो हमने ये साल ड्राफ्टिंग का किताब निकाला है जिसमें ऑल टाइप ऑफ ड्राफ्ट वी कवर्ड. दैट बुक इज अवेलेबल ऑन फ्लिपकार्ट एंड Amazon. And just type there Jayprakash Somani book, then you will get all my books, 61 books, and you can search out from that AOR book for AOR examinations. But we don't have that practice and procedure book till now. We'll try to launch in this year or next year. But I would like to add few things on practice and procedure. Practice and procedure in this paper, you should be clear what are the duties and what are the contents of the chamber judge. What are the contents of the SLPs? What are the contents of the criminal SLP, civil SLP? Order 20, Order 21. Then what are the contents of the writ petition? Writ petition is of two types. One is a regular writ petition. Both types are covered under Article 32. But one is a regular writ petition, another is a public interest litigation. In regular writ petition and in public interest litigation, in both also, you should have exhaust existing remedies. So such type of practical points, if you are considering from Supreme Court Rules 2013 and Supreme Court Practice and Procedure 2017, which Asima ma'am mentioned you very well. She shown all this to you on screen also. So you can write your paper in timely. And while writing paper on practice and procedure, so everywhere you mention the article, mention the particular rule of the Supreme Court procedure, and try to mention some case laws also in your answer paper. And categorize your timetable according to the question paper. If you are solving 5 questions, if you have to solve 5 questions, then give half hour to each question. 2.5 hours it will clear. Then you will get half hour, and that last in half hour you can recheck your paper properly. You can highlight your main points so that examiner can give you better marks. तो दोस्तों